You could be fined tomorrow for something that isn't even law yet. Here's what's actually happened. Over 15,000 people responded to the government's own consultation on pavement parking. 81% of individuals and 96% of organisations called it a genuine problem on their street. So the government acted. A new act got Royal Assent this year, giving councils the power to fine drivers up to £130. Sounds like it's done, right? It isn't. Buried on Parliament's own website is a research briefing written by their own staff, asking the exact question every driver actually needs answered. Is this law actually in force yet? Their answer, word for word, we do not yet know when it will come into force. Screenshot this. It's not me, it's Parliament's own House of Commons library, linked at the bottom of this description. Not a rumour, not me guessing. Parliament's own page, published this year, admitting the timeline nobody else is telling you. So before you trust another 10 new parking rules video, including this one, ask the only question that matters. Can you be fined for this today, or is it still just a promise on paper? I checked every single rule against the actual source. Here's exactly which is which. Rule 1. Pavement parking, passed, but not yet enforceable. Let's start with the most talked about one. The English Devolution and Community Empowerment Act got Royal Assent on 29th April 2026, giving English councils new power to fine pavement parking, expected at £60 to £130, mirroring London. Here's what gets left out. Secondary legislation is still required before councils can actually use this power. The government has only said further details come in due course. No confirmed date. Full rollout is talked about as by the end of 2026, but that's an expectation, not a start date. So outside London and Scotland, where bans already exist, you cannot yet be fined under this specific act. Rule 2. The 10-minute grace period. Real, but it's not government law. This is the one that surprised me most while doing the research for this video, because it's repeated constantly as settled law, and the real picture is messier. The underlying legislation is the Parking Code of Practice Act 2019, which received Royal Assent back in March 2019. That act gave the Secretary of State the power to write a single, government-backed code of practice for private parking operators. As of the most recent House of Commons library briefing, dated July 2026, the government had only just finished consulting on that code and told Parliament it would respond in due course. The official statutory code has not been finalised. What has actually happened is that the private parking industry, through its own trade bodies, published its own voluntary code, including a 10-minute grace period after your paid time expires. New sites were expected to comply from October 2024. Pre-existing sites have until late 2026. Screenshot this one because it's the strongest proof in this whole video. The House of Commons Library's own published briefing says, in plain English, we do not yet know when it will come into force. That's Parliament's own research service, about the government's own code, saying nobody currently knows when it becomes law. Links in the description. So, if you're ticketed at a new private car park and denied a 10-minute grace period, you likely do have a case, because reputable operators have already adopted it. But this is currently industry self-regulation, not a right guaranteed to you by an Act of Parliament. And critics, including the RAC, have said publicly that the industry-written version falls short of what campaigners wanted. Rule 3. The fine cap. Yes, but the exact number depends on who you ask. Following directly from Rule 2, private parking charges are being capped, but you'll see different figures reported, and here's why. The industry's own published code sets a cap of £100, reduced to £60 if you pay within 14 days. That's the figure the BPA and IPC trade bodies themselves confirmed. Separately, the government's original 2022 proposal, the one that never fully became binding law, wanted a tougher cap of £50 and £100 only for serious contraventions like misusing a blue badge bay, with a 50% early payment discount. Same pattern as before, two different numbers from two different processes at two different levels of legal force. And most videos just pick the more dramatic one without telling you which is actually binding today. Both numbers are floating around because both processes have happened at different times with different levels of legal force. Until the government's own statutory code is finalised, the safest thing to check is not, is my fine under £50? It's what the operator's own published terms say, since that's currently what's actually enforceable against you. Rule 4. Bad signage can still get your ticket thrown out. This one holds up well regardless of which version of code eventually becomes binding, because it's been a consistent principle throughout every draft. Private parking charges are, legally, a matter of contract. You're agreeing to terms displayed on a sign when you park. If that signage is unclear, obscured, too small, or doesn't give you a reasonable chance to read and understand it before you park, you have a genuine argument that no valid contract was ever formed. Ask yourself two things before paying any private parking charge. Was the signage clearly visible when I arrived, and does the charge match what the operator's own terms actually say? If either answer is no, that's grounds to appeal. This one you can rely on today. Rule 5. School street cameras. Real, established, and expanding. Unlike rules 1 through 3, this is not a new 2026 change dressed up as one. It's a real, already operating enforcement mechanism that's simply growing fast, and it catches people who genuinely don't know the rules apply to them. School streets, roads near school gates closed to traffic during drop-off and pickup, have been enforced by automatic number plate recognition cameras in a growing number of council areas since 2024, with restrictions typically running for a set window, often around half an hour to 45 minutes, morning and afternoon, during term time only. Fines vary by council. One published example, a £70 penalty charge, reduced to £35 if paid within 21 days, with the right to appeal. If you regularly drive a route near a school and haven't specifically checked the signage, check it. The restriction is time-based, and it is very easy to be unaware you're driving through one outside the hours you'd expect. Rule 6. Dropped kerbs. Old law, newly active enforcement. This is genuinely one of the oldest rules on this list, not a new one, but it's catching more people than ever, and that part is true and worth knowing. Parking across a dropped curb, whether it serves a driveway, a pedestrian crossing point, or vehicle access, has long been a parking contravention, enforceable by councils through a standard penalty charge notice. What's changed is not the law itself, but the enforcement rate. More residential streets now have camera coverage, and many councils will act on a resident's complaint without needing to witness the obstruction in person. Two things people consistently get wrong. You don't have to be blocking anyone's actual use of the driveway for it to count, and a dropped curb doesn't need extra yellow lines or signage to be enforceable. The lowered curb itself is the marker. Rule 7. Engine idling fines are ramping up. Councils have technically had the power to fine drivers for unnecessary engine idling for some time. What's genuinely new is how actively that power is now being used. Anti-idling enforcement is increasing specifically around schools and hospitals, with fixed penalty fines commonly reported in the £20 to £80 range, depending on the local scheme. The basic rule: if you're stationary and your engine is running unnecessarily, a civil enforcement officer can ask you to switch it off, refuse, or keep idling after being asked, and a fine can follow. Rule 8. EV charging bay misuse. As electric vehicle ownership grows, so does enforcement around the bays built for them. Parking a non-electric vehicle in a charging bay, or occupying one without actually charging, is increasingly being treated as a standard parking contravention, rather than something informally tolerated, with a number of retail and supermarket car parks now adding camera monitoring specifically for this. If you drive an EV, don't assume a charging bay is a normal space once you've finished charging. Move on promptly. Rule 9. A single unified appeals service, coming, tied to the same unresolved code. This sits under the same parking code of practice, Act 2019, as Rules 2 and 3, so the same caveat applies. The plan is to replace the current split system, Poplar for one trade body's members, IAS for the others, with a single, independent appeals service covering every operator. One more time, same proof. That single service is written into the same statutory code of practice that Parliament's own library says has no confirmed commencement date. Go back to that screenshot. Until it's formally in place, you're still working within the existing two-body system, depending on which association your parking operator belongs to. Check the ticket itself to see which applies to you. Rule 10. DVLA data access is the real enforcement mechanism behind all of this. Here's the rule almost nobody explains, and it's arguably the most important one because it's what actually makes any of this stick. A private parking company cannot pursue you for a charge unless it can find out who you are, and it gets that information from the DVLA. Under the Parking Code of Practice, Act 2019, access to DVLA keeper data is tied directly to compliance with the code. An operator that doesn't follow the rules can, in principle, lose that access entirely, meaning it can still put a ticket on your windscreen but has no legal route to chase you if you ignore it. That's the real leverage behind every rule on this list. Compliance with the code code isn't optional for operators because it's morally right. It's the price of being able to enforce anything at all. Before you pay any parking charge going forward, run through this properly rather than just paying to make it go away. 1. Work out which category it actually falls under: a council penalty charge notice or a private parking charge notice. They run under completely different rules, and confusing the two is the single most common mistake drivers make when appealing. 2. For a private charge, check the signage was clear, check the amount matches what that specific operator's own published terms say, and check whether you were within any grace period they advertise. 3. For a council PCN relating to pavement parking specifically, remember that outside London and Scotland, full enforcement under the new 2026 Act may not legally apply yet. Check your own council's current published position before assuming the national headline applies to your street. 4. Don't assume a video, including this one, is the final word on a fast-moving area of law. Check gov.uk and your local council's own published guidance for the current position before you pay or appeal. If you want the version of this that actually tells you what's law and what's still just an announcement, subscribe. There'll be another set of new rules headlines next year, and somebody has to check which ones are real.